Hi, my name is Alex Dolphin, and welcome back to another episode of Ex Ante. Today we're going to discuss the case United States v. Gundy. This case was heard in the Supreme Court of the United States in the year 2019. Let's go ahead and jump into the facts of the case. Mr. Gundy is a sex offender. He committed a sexual offense. Now, in this country, when you commit a sexual offense, most people know this, you have to register as a sex offender. Okay, but that wasn't always the case. There wasn't always a uniform system of a sex offender registry. That did not exist until Congress passed SORNA, the Sex Offender Registration and Notification Act. So SORNA basically created this coherent framework for sex offender registry throughout the country, right? To better track these sex offenders and kind of so people can know where they are at. SORNA was an interesting statute because they knew when they passed SORNA, Congress did, they said, we're going to apply SORNA to anyone who is convicted of a sexual offense going forward. So after the passage of SORNA, if you're convicted of a sexual offense, SORNA applies to you. That's pretty clear. Congress, though, wasn't quite as clear about what happens to those folks that were convicted of sexual offenses before the passage of SORNA. So these folks over here. Mr. Gundy is one of these folks. He was convicted of a sexual offense before the passage of SORNA. Now, Mr. Gundy, after the passage of SORNA, is charged with failure to register as a sex offender and is basically looking at 10 years in prison for failing to register as a sex offender. Now, how could that happen, right? If Congress wasn't all that clear about what happens to the pre-act offenders, how did Mr. Gundy get on the hook for this, right? And there is this provision in the statute, which is the key part of this case, what we're arguing about. And this provision Congress said the Attorney General will basically get to decide whether this statute applies to pre-act offenders. That's the grant of authority from Congress to the executive. The AG gets to decide, how and when this statute will apply to the pre-act offenders. And so that's the heart of the issue. Mr. Gundy is challenging this statute, that provision, on non-delegation grounds, constitutional separation of powers, right? Congress can't pass a statute that tells the executive, if it wants to apply this law, it can, and if it doesn't want to, it doesn't need to. That's too much. Congress can't delegate that much power away to the executive. But the court says otherwise. The court says, yeah, it can. And Justice Kagan writes the opinion. It's an interesting opinion because you have a very interesting split on the justices. Justice Kagan, Breyer, Sotomayor, and Ginsburg all write this majority opinion. And what it argues generally is that there is enough guidance in this statute that it passes non-delegation muster. So the intelligible principle test is what we generally look at for non-delegation challenges. And the intelligible principle test says, Congress just has to kind of give a framework. They have to give something clear enough for the agency or for the executive to work off of. They can't just say, hey, you can do whatever you want. They have to give them some little bit of a framework. And here, Justice Kagan says there is enough framework. There is enough of an intelligible principle. And she basically, and she's transparent about it, she reads into the statute this phrase, to the extent feasible. So she's essentially reading into the statute this feasibility requirement that allows the Attorney General to apply SORNA to pre-act offenders, people like Gundy, if it's feasible, essentially. That's not anywhere in the text of the statute. But she says, when we look at Congress's purpose and the legislative history of this statute, it's clear that Congress wanted this to apply to all pre-act offenders. Congress just didn't know how to do that. They were worried that there might be, some constitutional problems with like an ex post facto law or due process issues. And so they said, we'll just let the Attorney General, a really smart lawyer, figure this out and figure out how and how feasible it is to apply this to pre-act offenders. And if the AG says they can, then that's great. Let them do that. The other kind of just common sense argument that she makes is like, well, obviously Congress wanted this to apply to all the pre-act offenders, right? Like that's the big reason why they passed this act, was to make sure that those people who had committed sexual offenses were registering, and that people knew where these folks were at. They might be a danger to society, and Congress thought that. And so that is the opinion that 4 justices joined. Justice Alito writes separately to make it 5. He concurs in the judgment. But Justice Alito pretty clearly says that he's not a big fan of the current state of the non-delegation doctrine. He does kind of hint at the fact that he thinks that this is a problem with the separation of powers. He says that if a majority of the court were willing to revisit this decision, then he would support that effort, essentially. And then you have 3 justices writing for the dissent. Justice Gorsuch writes the opinion, Justice Thomas, and the Chief Justice, Justice Roberts, join that opinion. Justice Kavanaugh was just not on this case quite yet, right? So had Justice Kavanaugh been on this case, you might have seen something different. But what Justice Gorsuch says in his opinion is he said the majority really misunderstands the Constitution. They misunderstand separation of powers, and they even misunderstand the non-delegation doctrine. There has to be an intelligible principle. There has to be some framework. That's what he says. And we can't just read some type of principle into the statute to save it. He talks a lot about this case Reynolds, and where the court had done an interpretive move on this statute in the past to uphold its constitutionality, and basically did another roll to get out of this constitutionality. He kind of calls out the hypocrisy of the court in not striking down the statute. And he also says, as a textualist, which he clearly is, there's no feasibility requirement written into this statute. A lot of statutes, Congress knows how to write a feasibility requirement, and they will write that into the text of the statute when they see fit, but they did not write one in here. And it's pretty clear that Justice Gorsuch has a real problem with the fact that an agency or the prosecuting arm of the United States government also gets to decide whether that law applies to a potential criminal offender. And he just thinks that that is completely wrong. There has to be some line where you cannot delegate fundamental policy choices away to the executive branch. And that really is the key of his decision, is Congress can delegate some, but when they are delegating fundamental policy choices to another branch of government, that is not okay. That's a violation of our separation of powers and our constitutional structure. And here, Congress pretty clearly gave a full policy choice to the Attorney General. And he also says, just factually, different Attorney Generals have applied this law differently to pre-act offenders. So it's pretty clear that they are looking at this, as the Attorney Generals are, as some type of ability to choose the law and make these fundamental policy decisions. But the Attorney General, right, the Attorney General is not directly accountable to the populace. There is some accountability through the president, but it's not the same level as Congress, where this person is directly accountable to the folks at the ballot box. And so this is a very interesting case because it might signal the future of the court. It might signal the future of the non-delegation doctrine. We might see another case like this in the future, now with Justice Kavanaugh and Justice Barrett sitting, where this would actually go the other way. Now, it's important to know that even here, there was criminal sanctions for Mr. Gundy imposed by the executive, not imposed necessarily by Congress, right? These criminal sanctions were there. And maybe the court wants to draw a line where it says, in criminal matters, Congress can only delegate so much. Congress cannot delegate as much away in criminal matters because we are taking away people's lives and liberty. And that was one argument that was made in this case, in an amicus brief. And I think it's interesting to see if maybe the court will pick that up in the future. Maybe it won't. The real fact is that there's hundreds of thousands of federal crimes that are promulgated by agency heads, people who are not directly accountable to the public. And it seems as though the tides are kind of shifting on this, and the Supreme Court is looking at the vast power that our agencies have with a bit of a skeptical eye. Thanks so much for watching this video. I hope you enjoyed it. If you'd like to see more, go ahead and hit that subscribe button, and I hope you have a nice rest of your day. Bye-bye.